Good evening, everyone. Thank you for joining us. We are presently here today to talk about the Biological Diversity Act Amendment Bill of 2021, the issues and concerns. Before we go on to the talk itself, I'm going to make you run through a couple of house rules. Please keep yourself muted and your cameras off at all times so that we could give the speaker the space to be able to present what they have to. With regards to, we have Hindi interpretation available right now. And for that, please click on the globe like thing on the bottom of your screen which says interpretation and press Hindi. And you will be able to hear live Hindi interpretation of whatever is being spoken. For those who are unable to join the Zoom, please know that we have reached maximum capacity of 300 people, and therefore we also have it on YouTube. And you would have received the YouTube link on your registration mail from Zoom. नमस्ते, वेलकम एंड जिनको हिंदी में सुनने का यहाँ पे सुनना है, वो ये एक ग्लोब जैसा चीज है जो आपके बॉटम स्क्रीन में है, वो वहां पे आप इंटरप्रिटेशन जो लिखा है वहां पे जाके आप क्लिक करके हिंदी में क्लिक कर लीजिएगा हिंदी में सुनने के लिए. थैंक यू एंड ओवर टू यू नीमा.
Thank you, Shruti, and namaste, everyone. As Shruti mentioned, we have all gathered here to understand the draft Biological Diversity Amendment Bill of 2021. The fact that we've had more than 600 registrations is, and also there are many people watching this on YouTube channel today, it's very clear that the act is extremely significant and many people want to understand what are the proposed amendments and what would be the implication of these amendments on the biodiversity of the country, as also on the rights of the local communities which interact with this biodiversity. So who could be better talking about it than our speaker today, Mr. Ritwick Dutta, who doesn't really need any introduction, but still, we all know that Ritwick is a Supreme Court lawyer who has been involved in environmental litigation for last 15 years. Ritwick Dutta is also founder of an organization called LIFE, which is based in Delhi. LIFE is co-organizing this event with Kalpavriksh today. Through his engagement in the Supreme Court and also the National Green Tribunal, Ritwick and his colleagues have been directly responsible for saving or at least delaying the destruction of some of the most important ecologically and culturally rich ecosystems in our country. Many local community members considered Ritwick a very close and dear friend for supporting them in their struggles to defend their territories, their jal, jungle, and zameen, which are also environmentally very, very important. Many of us working on the issues of environmental justice and biodiversity conservation immensely benefit from regular updates and also advice, much needed perspectives that he and his colleagues bring out regularly as part of LIFE's outputs. Thank you very much for agreeing to do this talk at a very short interval, Ritwick. I wouldn't take much time. Just take 2 minutes to thank you also Mr. Anurag Modi, who's doing the simultaneous interpretation in Hindi for us today. Thank you. Over to you, Ritwick.
Ritwick, you'll have to unmute yourself.
Thank you, Nima. I hope I'm audible. I'm not in Delhi, so a little bit of connection problem may be there, but I'll try to make it as short and precise as possible. So I think the very fact that, 600 people have registered, others, shows that, there is an interest on this subject. And I think the Biological Diversity Act requires this kind of interest, given the fact that, among the various laws on environment, I think this is one law that normally has not been the focus of many groups. Despite its immense potential, I think this is one law which has somehow been forgotten, but actually is of great use, has great potential, and covers and is relevant for every inch of the country. So what I will be sharing today is the concern which many of us, many of you all here are aware of, but I'll try to highlight few. I think in 40-45 minutes, it may not be possible for me to cover each and every aspect of this law in terms, but I'll try my best again to cover some of the issues of major concern. But before, we go into the bill itself, this law which was passed in 2002, sorry, I'll just, next slide. Not going to the next slide, yes. Now, if you look at it here, the law that was passed, right, by Parliament in 2002 had a very important objective. One definitely is the conservation of biological diversity. The second, the sustainable use of its component. And the very important part, the fair and equitable sharing of benefits. And what is also very interesting is that this was a law which was passed in order to implement India's commitment under the CBD. But there's one very important difference. And the difference is that the concept of fair and equitable sharing of benefits in the convention, in the Biological Diversity Act, is specifically with respect to use of biological resources. If you look at CBD, it looks about genetic resources. So if you look at the third last line, it shows about fair and equitable sharing of benefits arising out of utilization of genetic resources. In case of Biological Diversity Act, it's taken a wider view. And the Indian Parliament actually says, why limit it to genetic resources? Use the word biological resources. So in a way, this law has a much wider ambit than what even CBD could have visualized. So three broad pillars we have: conservation, sustainable use, and fair and equitable sharing of benefits. 2002 law came into effect in 2003. Some of the important components or pillars of this law is, first, the biodiversity management committees. Every local body in India is required to have a biodiversity management committee, BMCs. I would call it as a real process of democratizing biodiversity conservation in India. Second, very important part of it is that these biodiversity management committees have to prepare what is called People's Biodiversity Register. And third, very important, is the fact that the users, the commercial users of this biodiversity, biological resources, are obligated to equitably share the profits and revenue that they get from the commercial utilization with the people who have conserved these biological resources. So I think this law is one of those post-independence era law, much progressive than even the Wildlife Protection Act, because it talks about handing or giving a lot of decision-making power to the communities itself, as at the same time ensuring that they get benefit out of it. Now, this 2002 law, unfortunately, like many other laws, never got implemented. And it's also a very classic case of, or a study of, how a litigation can actually make a law work. So this is the report of the National Biodiversity Authority before the National Green Tribunal in a case called Chandrabal Singh versus Union of India, which was filed basically showing that despite this law coming into force in 2003, there has been abysmal level of compliance so far as the provisions of this law is concerned. And this affidavit, which is very interesting, coming from a authority. And what it shows here is that on 26th of July 2016, when the original application was filed before the National Green Tribunal, India had 9,700 BMCs and 1,388 People's Biodiversity Register. the NGT directed that you must set it up. And through a process of what we call as continuing mandamus in one form by the tribunal, they directed the National Biodiversity Authority, the State Biodiversity Authority to take active steps in ensuring that the BMCs and PBRs are actually prepared. Now, there are question marks on the quality and the functional. That's an issue of concern. But the first step is something that should happen in 2002, 2003, 2004, needed a case from the NGT to actually give directions and to give credit. NBA took it in the right spirit and ensured that the orders of the NGT is implemented in letter and spirit. What we today have is that 265,000, this is August 2020, 265,725 BMCs have been constituted across the country. You look at the number of PBRs also, from 1,300, we have lakhs of PBRs also have been prepared in this country itself. And the latest figure is actually close to 275,000, right? It is 99% compliance so far as BMCs are concerned. So this is a law, though passed in 2002, has actually started working only in 2016 and 17. If you look at access and benefit sharing, 6 and 7, virtually nothing. And you look at 2021, the amount of money that is collected may still be a very, very limited percentage of what should actually have to the Biodiversity Management Committee. But nonetheless, it is much better than what used to be earlier. So what we are looking today is a law which has actually started working. And this is the tragic story of laws in India, that till the time it doesn't work, it doesn't get amended, it doesn't get weakened. The moment people started using the law, BMCs got constituted, PBRs getting made, written, and ABS started getting collected, fair and equitable sharing of benefits. That is when the government comes out with its amendment bill. Now, it's the interesting part of the amendment bill that is there is the amount that is there is, it was part of a series of process. Some of them within the knowledge of the public, some of them not. So if you look at it, 2018, a task force was formed by Dr. P. Jyotimani, who was a former member of the NGT and had former secretary of MOEF. That they talked about having an online portal for registration. Now, what is important is committee after committee, Amarjit Ahuja committee was set up, and they asked for revision of ABS guidelines. These ABS guidelines, against which I will deal with later, was an outcome of the Nagoya Protocol of 2014. And after that, the collection started. Then there was another expert committee of A.K. Goel, former IFS officer, and there they also had detailed consultations. Again, it's very important. No consultation was held with BMCs, none with civil society groups, none with the conservers and protectors of biodiversity. This is one law where the consultation was purely with the industry, research institutions, seed manufacturers, CII. And if you look at what I'm going to now cover, and many of you may be aware of it, not a single provision in this Amendment Act helps in conservation, sustainable use, and fair and equitable sharing of benefits that is arising out of biodiversity. It is aimed only at diluting the provisions of a law, which even today is largely unimplemented, but has a lot of potential of being used for the purposes for which the law has been passed. So if you look at it here, there are many committees that have been formed, but one particular agency that has been always there is the Ayush Ministry. This is the law whose author is the Ministry of Environment, but the real director of this movie script is actually the Ministry of Ayush. The Ministry of Ayush is Ayurveda, Unani, Siddha, and the Indian system of medicine. They are deciding today what the law should be, who should be penalized, who are to be treated as companies and entities who should pay FEBS. There is no role of conservationists, local communities in the entire process which led to the amendments taking place. Now, if you look at it here, now I'll come to few of these provisions that are there. Now, what a very important part and one very important addition, or I would say very problematic addition, is this use of the word saying codified traditional knowledge. Now, what is in pink is the existing law. What is in yellow here is what is the amendment bill. If you look at the definition here, benefit claimers means conservers of biological resources, the byproducts, holders of knowledge and information relating to the use of such biological resources, innovations and practices associated with such use and application. So what is very important here is the benefit claimer means conservers of biological resources and their byproducts. Here, they said benefit claimer means conservers of biological resources, byproducts, creators and holders of associated traditional knowledge, excluding codified traditional knowledge only for Indians. Now, this is a very dangerous addition, because what is meant by codified traditional knowledge? WPIO defines the World Intellectual as which is in some form. It is ordered, it is classified and categorized. So Ayurveda, which is in specific books, Unani, TCM, all of these are categorized and codified. Once it is codified, it is outside the purview of the law. So now if you look at it here, once an information gets codified, so the entire lot of Unani, Ayurveda, Siddha are all codified into specific books. This biological diversity, the major user today is the Ayurvedic industry, is the traditional Indian system of medicines. Now the problem today comes in that the moment they say codified, it goes out. Also very problematic is that if the traditional knowledge gets codified in people's biodiversity register, then also they can say, well, it is codified now, you're outside the purview. So the protection that was given in terms of all kind of knowledge, now they have taken it out by stating that codified knowledge is out. Now here, if you look at it in a very clear form, it says determination of. Now, why is this word code benefit claimer so important? Because now if you are a codified traditional knowledge is there, it will not be applicable or not be available to a benefit claimer. A benefit claimer, right, is one who has definitely gets certain benefits. Now here, the green one states what are the benefits. They get the benefit of grant of joint ownership to intellectual rights, location and production, research and development units in such areas, which offers better living standards to the benefit claimer. And it also talks about setting up a venture capital fund in aiding the cause of benefit claimer. So today, as the law exists, any today user who supplies medicines or raw products to an Ayurveda industry is a benefit claimer. As per the new amendment, because Ayurveda is a codified traditional knowledge, then in such circumstances, the people who are supplying it to them no longer come in the category as benefit claimers. So all the benefits that come to them in terms of better living standards to benefit claimers or setting up a venture capital funds and others are no longer available to them. Now, implication of the amendments here, what I've stated here is holders and conservers of traditional knowledge can no longer be part of the equitable sharing of benefits and other benefits that arise out of Section 21. The entire Ayush industry can be outside the purview of the Act because they said that we are using codified traditional knowledge. Once traditional knowledge is recorded in people's biodiversity register, it may be also claimed to be a codified traditional knowledge. So in a way, by means of codification, the people who are actually supplying, conserving, and protecting these resources are at a great disadvantage because whatever rights to equitable and fair and benefit sharing that they enjoy today is been taken away. Now, this is what I've stated here, that the entire Ayush industry, which is the largest will move away from the purview of this act if codified knowledge is exempt. That's it. So one entire industry moves out, which is the single largest user, by using this what's called codified traditional knowledge. Now, again, one very important point that they have made is what is a biological resources? Now, biological resources, again, the pink one, which is there, is of the existing law. It says biological resource means plants, animals, and microorganisms or parts thereof, their genetic material and byproducts, excluding value-added product with actual or potential use of value, but does not include. This is the existing law. Now they're changing the word byproducts with derivatives. Now, byproducts is something that is easily understood. What is a derivative? And derivative is now defined in the law as it's impossible to understand what it means. Naturally occurring biochemical compound or metabolism of biological resources, even if it does not contain functional units of heredity. And what is a byproduct? It was not defined, but a very simple dictionary meaning is something that is produced as a result of making something else. Now they have changed it to a derivative. And naturally occurring biochemical compound or metabolism of biological resources, even if it does not contain functional units, which is exactly the definition which is given in WPIO. Another point that I would like to highlight here is with regard to bio-utilization. Now, if you look at it here, the first part is the existing law. Well, in the definition clause, they very clearly say biosurvey and bio-utilization means survey and collection of species, subspecies, genes, components, extracts of biological resource for any purpose and includes characterization, inventorization, and bioassay. In the new one, what is bio-utilization for? Bio-utilization is essentially for the biotechnology industry, among others. This entire bio-utilization has now been deleted. What they have now stated is biosurvey means survey or collection of taxa, varieties, genes, components, and extractions for any purpose. Now, this again is something which is not a small thing, because the entire purpose of bio-utilization was a very, very important part of this law. This has been taken out. Again, serves no conservation purpose, serves no purpose when it comes to sustainable use and fair and equitable sharing of benefits. Now I come to a very, very important part of the law, which is actually where a lot of changes have happened, is with regard to Chapter 2. Now, Chapter 2 says of the existing law, certain persons not to undertake biodiversity related activities without approval of the Biodiversity Authority. Now it says certain persons cannot obtain any biological resources or knowledge associated thereto for commercial utilization or for biosurvey and bio-utilization. Mark it, the word bio-utilization is now gone. But existing law says that a person who are required to take approval of NBA includes a person who is not a citizen of India, yes, a foreigner, a citizen of India who is a non-resident, as defined under the Income Tax Act, a body corporate not registered in India, and last is incorporated or registered in India under any law for the time in force, which has any non-Indian participation in its share capital or management. So if there is a non-Indian in either the share capital or management, then that entity is required to take approval from the NBA. This is the existing law. So this is where foreign companies and others, or a foreign entity, even if they have a share capital, a non-Indian participation is there, NBA approval is required. The new law today, the amendment bill says that incorporated or registered in India. So I just go back to, which I have marked in green, is now deleted or proposed to be deleted and replaced by something says incorporated or registered in India under any law for the time being in force, which is a foreign controlled company. Now it says, what is a foreign controlled company? Foreign controlled company means a foreign company within clause 42 of section 2 of the Companies Act of 2013, which is under the control of a foreigner. So a foreign controlled company is now required to take an approval from NBA. But if a company has foreign non-Indian shareholders or non-Indian in the management, it is no longer required to take NBA approval. And what is very interesting here is that clause 42 of section 2 of the Companies Act does not actually refer to foreign controlled companies at all. If you look at it here, 42 says company. It does not use the word says foreign controlled company. Foreign company means a company or a body incorporated outside India, which has a place of business in India, whether by itself or through an agent, physically or through electronic mode, and conducts any business activity in India in any other manner. Now, if you look at it here, foreign company, as per the Companies Act, says it has a business in India, whether by itself or an agent, physically or through electronic mode, and conducts a business activity in India in any other manner. If you go here, this is the basic difference. Proposed amendment says foreign controlled company, and a foreign controlled company has been defined to mean that. End result, a foreign company incorporated in India need not take approval from NBA. An Indian company that has non-Indian participation also need not take approval. It will give a free rein to MNC, because all an MNC need to do is actually to set up an Indian registered entity. A free rein to even MNCs to have access to biological resources as long as they are registered in India. Section 3 requiring prior approval will become redundant, as all companies functioning in India will came to be non-foreign companies. Significant number of companies, Indian and foreign, and even foreign companies, will be exempted from prior approval. So for whatever that they say about make in India, made in India, Atmanirbhar, we can actually have MNCs actually taking control over biological resources. The only thing they have to do is actually to register themselves to India. They can actually have foreigners both in the share capital as well as the, so long as gets registered in India itself. Now, why is everything happening? Why is this amendment coming through? My point is, this amendment is essentially aimed at only one, and that is to overrule the judgment of the Uttarakhand High Court in a case called Divya Pharmacy versus Union of India. This is a case where the Uttarakhand Biodiversity Board had imposed fees on Divya Pharmacy under the fair and equitable sharing of benefits. Divya Pharmacies challenged the entire thing by stating that I am an Indian entity, and because I'm an Indian entity, I do not need to share and give benefits to the local community. And that is what I will read out, that the Uttarakhand High Court, Justice Sudhanshu Dhulia, I think the landmark judgment which has not been overruled by either the division bench or the Supreme Court, but will now be made redundant because of this amendment. And my analysis is that the entire aim of this amendment is to undermine the decision of the Uttarakhand High Court, which has actually held that the NBA as well as the government of India did the right thing by putting it fair and equitable sharing of benefits. This is what Justice Dhulia says. After going through the entire history of the movement, which is a movement towards conservation of biological diversity, and all the rights of indigenous and local communities were extremely important and emphatically declared in Nagoya Protocol. The rights have to be protected equally from outside as well as from within. Within means you have to protect the rights of the people within the country from entities within the country. CBD as well as the Biological Diversity Act is not between two different countries. It is between countries and it is within the country. And that is what was stated very clearly. And now I come to the other one, which is very, very important, which relates to the same thing. What is prior approval that is required? Now here, it is very, very important to, is that a lot of it is about Section 7. Section 7 says, well, if I look at the earlier Section 3, It says if you are a foreigner, you need to take NBA approval. If you are an Indian, no person who is a citizen of India, body corporate, or an organization which is registered in India shall obtain any biological resources for commercial utilization, biosurvey, bioutilization, right? Unless and until they take approval or give prior intimation to the state biodiversity board. Now I'll come to it. It's not just an intimation. Intimation will lead to an inquiry. The inquiry will lead to a where the state biodiversity board will decide whether to grant or not to grant, and if to grant, what will be the sharing of benefits with the local community. Existing laws specifically exclude vets, hakims, growers, cultivars of biodiversity from, and those practicing indigenous medicine from taking approval under SBB. So it is in the right direction. Vets and hakims and other users and cultivators do not need to take approval from the biodiversity boards. But who are required is that any other citizen who wants to use it for commercial purposes or a corporate entity do need to take prior approval. The new law today, the bill now disturbingly says something very, very dangerous. The provisions of this section shall not apply to the codified traditional knowledge, cultivated medicinal plants and its products. Local people and communities fine, including growers and vets and hakim. Next important, registered Ayush practitioners who have been practicing indigenous medicine, including Indian system of medicine, for sustenance and livelihood. One can understand what is livelihood, what is sustenance. So what will happen is exclusion of codified traditional knowledge. It's out. Exclusion of cultivated medicinal plant and its product. And I will deal with it. There is no way the SBB or the NBA can actually find out whether the product is using wild collected one or cultivated ones. Using the point of cultivation, the idea is actually to allow a free rein to collect as much wild plants are concerned. Sustenance and livelihood, there's no definition. What is sustenance? What is sustenance for A will differ from person B. And registered Ayush practitioners and ISM. There's nobody else. Everybody is out. Veds and hakims were, and growers and cultivators were out. Now exclusion of codified traditional knowledge. Ayurveda, Unani, Siddha, all of them are today out. If I say I'm a user of more contemporary medicine or product, I can say it is through cultivated. So what is the process that is followed today? Under section 70 requires prior intimation to be given to SBB for obtaining biological resources for commercial utilization. SBB has powers to regulate the grant of approval. SBB has to consult local bodies and can conduct inquiries, has the power to restrict such activities, and restriction and prohibition on the ground that such activity is detrimental to conservation, sustainable use, and equitable sharing of benefits. Today, with the range of actors that are out, nothing will actually come here. Nothing really will come here because everyone will come under one category or the other. Now, if you look at it here, I'll dive a little bit into why I'm stating that the entire aim is to undermine the Uttarakhand decision. This is from Divya Pharmacy. In Divya Pharmacy, the court said the local and indigenous communities of Uttarakhand who reside in the high Himalayas are traditional pickers. The knowledge may not strictly confined as intellectual property, but nevertheless is a property right. Can it be said that Parliament on one hand recognized the valuable right of local communities and failed to protect it from an Indian entity? Could it ever be the purpose of legislation? Biological resources are definitely the property of the nation where they are geographically located, but they are also the property in the manner of speaking of indigenous and local communities who have conserved it for centuries. This is truly a landmark judgment where the court actually held that these biological resources are actually the property of the local community. And interestingly, not even one consultation was held by the Ministry of Environment when drafting this amendment with any local community member anywhere in the country, and it is on record that they only consulted the industry, Ayush, and the research bodies. So what I'm stating here is, if the source, now what is very important is fair and equitable sharing of benefits, because ultimately, if it's a benefit claimer, it's a local community. Under this law, and I'll deal with it, there is a requirement of fair and equitable benefit sharing. Once you're out of 7, you're out of section 23 and 24, which requires an inquiry to be done, consultation with the local bodies, and then only the resources have to be taken. So therefore, we actually take out the entire equitable sharing benefit for a range of people. That's why I'm saying it will undo the impact of both the Uttarakhand judgment and India's commitment under the Nagoya Protocol to the CBD, which is about fair and equitable sharing of benefit. Now, what does the court say? Now, this is what the court says here. Very interestingly is that this is from the judgment itself. This is the trust founded by such and such Swami Ramdev and Balakrishnan. It is admitted fact that biological resources constitute the main ingredient and raw material in the manufacture of Ayurvedic and nutraceutic products. Petitioner is aggrieved by the demand raised by Uttarakhand Biodiversity Board under fair and equitable sharing of benefit. Petitioner's case is simple. Uttarakhand Biodiversity Board cannot raise a demand under the head fair and equitable sharing of benefit, as the board neither has power nor jurisdiction to do that, and petitioner in any case is not liable for make any contribution under this fair and equitable sharing of benefits. Now, the petitioner would also argue that the State Biodiversity Board has no power to impose FBS in respect of Section 7 in respect of Indian entities. NBA does not have the power under this Act to delegate its power to SBB. In short, the petitioner would argue that there is no provision in this Act where the contribution in the fee of monetary compensation or any contribution should be given by an Indian entity. FEBS is only for foreigners. That's it. That was the contention of Divya Pharmacy. And the court says, what is fair and equitable sharing of benefit? It says very clearly, and I think it's a must read for anyone who wants to understand fair and equitable sharing of benefits, that the benefits that the indigenous and local community get under the law is over and above the market price. It is in return of parting with the traditional knowledge that actually they get certain benefits. And the court goes on, because of time, I'm not going into too many details, but Nagoya Protocol focuses on fair and equitable sharing of benefit, including traditional knowledge. That's what the court says in its order. The concept of FEBS is focused on benefits to local and indigenous community, and Nagoya Protocol makes no distinction between foreign entity and Indian entity as regards their obligation towards local and indigenous community. This is exactly the point that this bill actually addresses. It wants to create a distinction between a foreign entity and Indian entity. Neither the biodiversity nor the local community anyway differently if they lose their biodiversity or there is an extraction, the impact is there irrespective of whether it is Indian. And the High Court actually goes into it. It doesn't really matter. And what are we talking about at the end of the day? You know, there are other calculations, but one part of the benefit sharing is very important. These companies at the end of the day, you know, are required to pay an amount. Now, this is the government guideline. Please have a look at the guideline. How much does an income tax an individual taxpayer today pays? 10%, 8%, 9%? This is the amount that under fair and equitable sharing that a company is required to pay. 0.1 to 0.5% of the gross ex-factory sale of the product. That's all. 0.5. There are other calculations for nothing, but in no case, it exceeds 2 to 3%. But even in most instances, all it goes is between 0.1 to 0.5. So if you're earning about 1 crore, all that is required to be paid under FEBS is 0.1% of the 1 crore. That's all. And that is the amount on which today there's an idea, and there's been said Well, because of fair and equitable sharing of benefits, the Ayurvedic and Unani industry is not able to make further progress in the country. And what is this amount going to go? This amount is actually going to do is to sustain the resources on which the companies depend. It is going to go to the BMCs. And what the court says is National Biodiversity Board, ultimately looking into it, para 106, the court is of the opinion that the State Biodiversity Board has got powers to demand fair and equitable benefit sharing from the petitioner in view of the statutory function given in Section 7, read with Section 23. And NBA has got powers to frame necessary regulation in view of section. The challenge to the petitioner to the validity of the regulation fails. That's it. So the challenge failed. They wanted to say that the guidelines issued by the National Biodiversity Authority pursuant to the Nagoya Protocol, which made it mandatory to collect ABS fees, is ultra-virus act. The court said no, it is not. And every entity, even if it is in Indian, has to pay money to the local community. And they have to share it. It is not just something that they cannot do. And in 5 minutes, just to end few of the other issues of concern. Why medicinal plant? Yes, it may seem good. We will encourage, but there's nothing stopping people from going medicinal plant and selling it to the industry. Excluding it would mean that you encourage what is called symbolic cultivation of medicinal plants. More than 80% of all these pharmaceutical companies and Ayurvedic companies depend on wild collected ones. As a result of this exclusion, they can have few acres of land, show them as the cultivated areas, and actually collect the bulk of it from the market. Neither NBB nor SBB has the mechanism to actually find out whether the source is from the wild or the source is the agricultural land. This will actually open up the entire wild area to large-scale collection. So what I'm saying is, again, all Ayush manufacturing companies can claim that the products are cultivated, finished. So the final point is, what is penalties? Now, one of the very main aim of this law was actually that, you state what is the main intention, that it is a criminal offense to destroy biodiversity. So the existing law says that the fine may extend, there will be any violation will be punishable with an imprisonment for a term which may extend to 5 years or may extend to a fine which is up to 10 lakhs. And where the damages exceeds 10 lakh, this is what it is. So there is a fine and there is an imprisonment. And if there's further the violation, there is punishable with imprisonment. The new bill does away with the word imprisonment. There is no imprisonment. All that is required today is, so long as you are willing to pay the penalty, you can violate the law. This is the real intention, that it is no longer a criminal offense. And it's interesting because when you see the Wildlife Protection Amendment Bill, which came in at around the same time, the entire penalty provision is about using higher amount of penalty, higher amount of fine in order to become a deterrent. When it comes to biodiversity, it's just the other way. And what 55A says is something even more interesting. It is the first time, or let me say it, one of the rare instances where judicial authority has been replaced by executive authority. He says, who will determine the penalty? A joint secretary to the government of India or the secretary to the state government will decide the penalty, not a judicial magistrate. So earlier, moment an offense is done, it is a criminal case to be tried by a judicial magistrate. Now, the penalty will be a penalty to be decided by a joint secretary to the government of India. And most probably, it will be an Ayush Ministry joint secretary. And an appeal against the joint secretary will lie before the National Green Tribunal. That is it. And let's look at it here. The final one. This is the existing law. Offenses to be cognizable and non-bailable. The offenses under the Act shall be cognizable and non-bailable. This is what the existing law is. And this is what the bill proposes. Section 58 of the Principal Act shall be omitted. So 58 that I'm showing you will no longer exist. The message is very clear that this is a law that will be meant only for the benefit of four: the Ayush industry, the Ayush industry, the industry as a whole, the seed, and I have not covered the seed in detail or mentioned it, but that is also that those which are protected under the plant varieties one will also be excluded, and the research institutions. This is where, and they make it very clear that in the statement of objects and reasons, it's good to be transparent. It's good to be transparent even if the consequence is odd. And they've stated that this law is coming in because of concerns that have been raised by stakeholders. And who are the stakeholders? This is what they state: Indian system of medicine sector, the seed sector, the industry sector, and the research sector, urging to simplify, streamline, and reduce compliance burden. And in order to encourage conducive environment for collaborative and investment, simplify patent, widen the scope of access and benefit sharing, and for further conservation of biological resources. I end by stating that there is not even one section in the new bill that talks about conservation, which talks about fair and equitable sharing of benefits, and that talks about a sustainable use of biodiversity. The focus is absolutely clear. It is about use, it is about exploitation, and it is about providing benefits. This is one law where the government's intention is absolutely crystal clear, that it has been made only and tailor-made to meet the requirement of an industry which believes in exploitation and not really contributing to the sustenance of the resource on which their profit depends. Thank you.
Thank you so much, Ritwick. I can already say that a very strong response needs to go from a large section of people for these draft amendments. But I also, before we take on the questions, I also understand that it's not an act which is very easy to understand. And you were mentioning right in the beginning that it's one act which has been under implemented. And one of the reasons is because largely it's very difficult to understand its various provisions, particularly the ones related to access and benefit sharing. So for the people who are attending today, we just also wanted to make an announcement that I think Ritwick did an amazing job of trying to explain it in as much simple words as could be done. But at the same time, we would try to make the recording of the presentation available, because you may want to go through it once more in your own time. Also, one of the things which he's very kindly agreed to do is to write up a note based on this presentation. Also, some of the issues which, Ritwick, as you said, you've not been able to cover in this presentation, because there are many other aspects which today couldn't be covered in this short span of time. So Ritwick will be making that note also based on discussion today after this presentation. And we hope we really would make an effort to circulate that note as widely as possible, definitely to all the people who have registered for this webinar. Just to quickly add that there is a joint parliamentary committee that has been formulated, as many of you may be aware, to look into the amendments, and it would be extremely useful as many responses as can go to the Joint Parliamentary Committee before the next parliamentary session when they're supposed to present their report. It would be very useful if some of this could be simplified and presented to also the biodiversity management committees, because it's going to immensely impact many of them. And submissions could go directly from the biodiversity management committees. I would stop here because I can already see there are many questions. We will just follow with a discussion. Over to you, Meena. Thank you.
Thanks, Nima. Ritwick, there are quite a few questions. So I have clubbed some, and maybe we can start with the working of the BDA currently. There are lots of questions related to that. So somebody has written in that, can the NBA and the SBBs work in a better way? Why are the NBA and except a few SBBs not involved in field work? And why hasn't the act been taken before the public? Many people...
Okay.
Yeah, just to complete, many people don't know about the existence of the act, and how, in that case, how will the BMCs survive or function?
Yeah, this is a very important question. In fact, let's accept it that, the SBBs today or NBA is not really what has been envisaged in the act itself. They are underfunded, understaffed. And you look at it today, let's be very honest about it, that State Biodiversity Board is still seen as a punishment posting for serving IFS officers. So if someone has to be removed as a chief wildlife warden, the first parking post for them will be as chairman of the Biodiversity Board. Right. So this is where the entire rot has come in. The chairpersons of all or the member secretaries of most biodiversity boards are a deputation post. They're there for 6 months, 5 months. Nobody really knows what they are supposed to do. And that has really created the whole lot of problem that we see. At the same time, with among civil society groups, other than very few, many of us have not really focused on SBB. It's a collective failure. Even as an institution, we regarded that we have not really worked strongly with them. So, and I think even with the media and all, we can actually easily tell who is the chief wildlife warden. People will not be able to say where's the SBB even located. Also, I think the SBB has not really done a great work in actually transferring the money that has come under ABS to the BMCs that are working. So that there is a lot of work that needs to be done. There are some good examples, but it's far and few. And I think effort needs to be put in. And I think more and more groups of, whether they work on rural issues or environmental issues or any other issues, I think have to focus more on the functioning of BMCs and other entities, SBBs.
Thanks, Ritwick. There are 2 more questions regarding the current functioning. Who can book violations under the BDA? And what are intermediary BMCs?
I don't know about intermediary BMCs, but in terms of booking it, there is a notification issued by the Ministry of Environment authorizing certain Forest Department officials at a particular rank to file complaints under the provisions of the Biological Diversity Act. Powers have also been vested with the SBB to actually book cases. In addition to that, a benefit claimer can also file a complaint under the law. So there are a range of people who are empowered to do it. But so far as the government is concerned, there has to be a notification to that effect, which empowers particular class of officers to actually file a case. In fact, one of the very landmark cases under the BMC was with respect to the state of West Bengal, where, a Czech scientist from the Czech Republic had actually come to, basically collect butterflies. And those butterflies were not listed in the Wildlife Protection Act, but they were listed in the Biodiversity Act. And it also, irrespective of the species, it is a use of biological resources by a foreign entity. So there the complaint was filed by the Forest Department, and actually the people were sentenced to 5 years imprisonment. It's another matter that they jumped the bail and ran away. But the fact is, it did take place in those instances.
Thanks, Ritwick.
And intermediary BMCs, I'm sorry, I'm not aware whether there is any such provisions, but I may not be able to answer that.
Okay. The next is a set of questions on codified knowledge. So the first is, could you please shed some light on codified traditional knowledge only for Indians in the amended definition of benefit claimers?
Yes. There is the definition of codified traditional knowledge is, if you look at it, is very clearly, stated in WPI, the intellectual property organizations, where they said that so far as codified knowledge is concerned, it must be in one of the books of Ayurveda, Unani, Siddha. So these are the codified knowledge. Now, in this law, when they say that it is only for Indians, it's not actually very clear what they mean. One of the point that my interpretation, because, subject to any correction, because please don't take whatever I'm saying as the final word, because as any lawyer, there can be two interpretation. But my point is what they say is, so long as the codified traditional knowledge is used by an Indian entity, then it is not to be treated as a benefit claimer or will not come under the provisions of Section 7 and others, which are restrictions. So if a foreign entity today uses that codified traditional knowledge, then they may come under the provisions of this law. But if an Indian entity is using it, because, if you look at it here, the entire decision in Divya Pharmacy was only about the fact that every Indian entity is within the scope of the Biodiversity Act. And the entire focus of the amendment law, except one or two areas where they are giving it liberal for, foreign entities to come in, essentially is to give benefit to Indian entities by stating that as long as you are an Indian entity, you have the right to do whatever you want. So this is my interpretation so far as the Indian part is concerned.
What logic do those amending the Act give for excluding codified knowledge from the purview of the Act?
There's nothing, we don't have the discussions in the meeting and others. But so as it typically happens, the law, we only know in terms of what has been substituted and what has been added. The statement of objects and reason very clearly says to facilitate investments. So the moment, what I would say it is to ensure that, more investment. But again, there's a caveat. There's nothing to show that either the SBB or the NB has actually denied permission to so many entities, that the Ayurveda industry is today not able to grow because of these restrictions that have come in. So it's the other way around. It's difficult to actually say. On the other hand, taking an approval, according to me, or ABS, serves a very important purpose. And that is that as consumers, we come to know from where the resource has been taken. See, it's a very simple one. If I'm buying, say, Chavanprash, and it says it is comprised of these 20 herbs, most of them say collected from various forest and other areas. Yes, if you pay FEBS, fair and equitable sharing, then the money will have to go to the BMCs from where the amount has been collected, the product has been collected. Mechanism, I also come to know that the product that I'm consuming is actually coming from a genuine source, collected from a forest, from traditional collectors or conservers. Tomorrow, tomorrow I'm not required to show them merely because I'm in codified traditional knowledge like Ayurveda. I'm not required to pay ABS. I'm not required to pay anything to SBBs and others. I can actually, collect sugarcane, gur and others from Punjab, put it in and market it by saying that all of them are collected from herbs from different forest areas in the country. So from the perspective of a consumer also, I feel that the entire idea of putting codified traditional knowledge, excluding codified traditional knowledge, or the fact that they don't want to pay that 0.1% is essentially for one basic purpose. And that is that they don't want people to know the origin of the products. So the moment you pay 0.1%, I also come to know whether the product is coming from Sikkim, or it's coming from Uttarakhand, or it's coming from the fields of Haryana and Punjab. That's it. So to answer, or maybe this is not an answer really, but the fact is, by creating all these exclusions from codified traditional knowledge, cultivable plants, you actually are also telling or not giving information to the consumer of these Ayurvedic products and others as to the real source of the product that is there.
Thanks, Ritwick. There are some on the definition of biological resources. With the new definition of biological resources, would coal be a biological resource now?
No, I think this has been debated a lot, and there's a judgment to this effect because, one can say that, there was a whole argument about stating that, coal is a plant product. It has what, but at the same time, we must realize that the provisions of this act must be linked to the purpose under which the law has been enacted. The purpose of this act is to protect biodiversity. So coal is not biodiversity. So the argument that was made in the NGT was, well, a wood is also a dead matter. A coal is also dead. So why is wood included and coal not? So they went into the entire definition, the purpose of the law. And really speaking, there has to be some connection. So it may take, millions of years for an actual tree to convert itself into a coal. But the ground cannot be that, if you are using coal, you will end up, cutting a live tree which has converted into coal. So the purpose of this law is protection of biological diversity, and that does not match with the requirements so far as protecting coal is concerned. Charcoal maybe, but not coal.
The next is, are traders of medicinal plants exempted?
See, traders of medicinal plant are exempted from the purview of access and benefit sharing because they are not the end users. So they are excluded from the purview. So a lot of middlemen, lot of traders are there. So in terms of the provision of this act, traders do not come within the scope of this act.
Ritwick, there's a question on access and benefit sharing as it pertains to the Act currently. How do we enforce benefit sharing clause of the Act? It seems even the boards don't have a clear knowledge on what to do after collecting PDRs.
So this is an issue. The law is very clear that the amount that is collected has to go to the BMCs. Right? This has to be the process that has to be followed. Unfortunately, this is not happening. And I would again say that is because of lack of vigilance by civil society groups as well as community groups. It's good that in some instances is happening, but this amount should go, and it must go back to the community exactly who's conserving and protecting the resource. And at present, I would rather say these are the areas where the reform could have taken place. These are the areas where there is lack of clarity. There's mention of biodiversity heritage sites, but there are no specific procedure, guidelines, and processes to be followed. There's a mention of a biodiversity impact assessment under Section 36 of the Biological Diversity Act. There could have been clarity on this. There should have been clarity with regard to how the funds that are collected as ABS actually reach that community which has actually protected and conserved the resources. That was where things could have happened. Unfortunately, rather than looking at it from the side of the community, the users, the protectors, the conservers, the entire law has been amended only from the point of view of the industry and the government, and all, not even government, let me put it clearly. It's only with respect to the industry and specifically the Ayush industry. And this area of money going to BMC, what the BMC is going to do with the money, that's also very important. We found that, after they get the money, they really don't know what to do with the money. So that again is something that requires a lot of directions, lot of effort on the part of both SBB and NB.
There are a lot of questions on the Act with relation to other acts, the other environmental acts. One of the questions is, please share your opinion about how the approval of Indian Environment Service may impact the Biodiversity Act and other acts related to the environment.
See, this is still very early, about the Indian Environment Service. Somebody has filed a petition in the Supreme Court. Supreme Court itself has said that prima facie, we don't feel that a mandamus can be issued to the government to create an Indian Environment Service. And any case, the Indian Environment Service is the origin, as they say, is the TSR Subramaniam Committee report, which itself talks essentially in the same way as this bill is, about how the environmental law can be facilitated for the industry rather than being a protector of environment and the communities. So I think that requires a larger debate than on this Biodiversity Act. But just to take it, I think there is one issue. I think the Indian Forest Service today itself needs to be more oriented towards the Biological Diversity Act. There is a need, because they're still trained essentially on the Indian Forest Act or the State Forest Act and Wildlife Act. The emphasis on the Biodiversity Act is very, very limited. And that is one of the main reasons why this law is also not working well.
That's interesting, Ritwick, because the next question is kind of leading to the answer that you've given. What is the correlation between the BDA on the one side and the Indian Forest Act, Wildlife Protection Act, Forest Conservation Act, Forest Rights Act, and various state nationalization acts enacted in the 1960s and 70s? Are there any conflicts, and how do we resolve them? A related comment, I think, was the jurisdiction of the institutional structures such as Biodiversity Management Committee and Central State Biodiversity Committees and the intent of the BDA are no longer applicable to the CFR forests as defined under FRA. So can you comment on this?
See, the last part, I'm not aware of it, but I can tell you with regard to the general part is that this Biological Diversity Act is complementary to the other laws. And it's also important to remember that, that the Forest Rights Act, Forest Rights Committee is limited only to forest areas, right? And most of the other committees and bodies, whether it is on wildlife and all, have a very limited jurisdiction. On the other hand, biodiversity management committees has to be for every inch of India. Delhi constituted a biodiversity management committee and a council only last week, because even whether one is at urban area or in a rural area or in a forest area, every part of India should have or be covered under the jurisdiction of one BMC. According to me, it can play a supplementary role, a complementary role, because, if there is diversion of forest land, if there is diversion of or destruction of environment, the BMC's view has to be critical, because unlike a JFM committee, which is only an administrative body, an executive body, the BMC is a statutory body. So, and both the FRCs and BMCs can be there in the same area. The BMCs can be there for agriculture area, city areas and all, and they can all work together in order to conserve and protect the rights. The ABS benefits can only come to a BMC. So to answer the question, I think all of them can work together and can be complementary to each other. So there's no inherent conflict in any one of them. In fact, if you see the Supreme Court judgment with regard to Dibru-Saikwa oil drilling, they said that you've got approval from the National Board for Wildlife. Justice Lokur and Justice Deepak Gupta says that's not good enough. You must do an additional biodiversity impact assessment under the provisions of the Biological Diversity Act. That is over and above the wildlife assessment that has been done. So the project had an EC, an environmental, it got approval from the National Board for Wildlife. And then the Supreme Court still said, you must do a biodiversity impact assessment through the Biodiversity Board to look at the biodiversity value, which is much more than just wildlife. So you're looking at even traditional varieties of rice, agricultural practices, traditional knowledge, all of them have to be taken into consideration.
That's very interesting, Ritwick. The second is kindly throw some light on the implementation of the BDA in Schedule 6 areas.
I'm not aware how effectively in Schedule 6 areas BDAs are working. You have states like Meghalaya, you have states like certain areas of Mizoram and others which are included. But I think it'll be interesting for someone to, focus on the working, if at all it's working in these areas. We as a group, we have just completed a study which my colleague Dharmesh has done with regard to implementation in the state of Kerala and Karnataka, and my colleague Konkona has just completed or doing a study so far as West Bengal is concerned. But it's a very important point. It'll be interesting to see in 6th scheduled areas where the community has much greater power than even 5th scheduled area, how these bodies are actually working. But very honest, the fact is that despite the NGT orders, and let me say that some effort by also the National Biodiversity Authority, one does not undermine, but it is still at the formative stages. In order to show compliance, most state governments have constituted BMCs, but I don't think so they really know what they're supposed to do. So there needs to be a lot of effort towards capacity building and telling them, or at least sharing with them, what is their statutory duty, rights, responsibilities under the law. So I can say that anyone who goes to study the 6th scheduled area, I'll be happy to get any inputs on that.
Thanks, Ritwick. There are some questions on our future strategies for what can be done with this draft. One of the questions is, if this amendment is implemented, corporates will loot all biological resources and lead to disturbance in ecosystem. We should stop man-centric view and should look into nature-centric view. What can we do to stop this?
See, that the interesting part is, why I shared the first slide is that, see, from 2002 to 2016, no amendment was ever thought. And the reason why no amendment was ever thought was because the law was not working. 16 onwards, you suddenly have across India 275,000 BMCs, PBRs have been prepared. So what the industry is today worried about is not what the law is today, because today it is largely still unimplemented. What they are worried today is that what happens if 50% or 20% of all the BMCs get together and say, well, you can't take away my resources, collect it at 10 rupees per kilo from me, or 5 rupees a kilo, or 2 rupees a kilo, and sell a product, in a fancy place for about, 3,000 rupees for 100 grams. That's the price at which this industry is working, and there, what happens today is that community that has conserved, protected it, gets that 5 rupees, gets that 4 rupees. And the industry, which has not contributed anything for the conservation and protection, and today doesn't want to even part with 0.1% to 0.5% of the 3,000 rupees product that it is selling, right? They want to get away without any liability on regeneration. And I think this needs to be challenged. I think we need to explain, because the industry is doing a good job in telling the government what their problem is. And I think collectively issues, I think there is a requirement for communities, civil society groups, and anyone who is concerned about it to come together to actually explain how a process which could actually be a model for the world to follow will be completely undermined because of an amendment which is not only contrary to the act itself, the main objective, but also is in complete violation of the Convention on Biological Diversity as well as the Nagoya Protocol. I think it's and see, when I look at this bill, I stand corrected if anyone can prove to me, but I was unable to find even one provision of law, one provision in this law, which is actually meets any of the 3 objectives of CBD. Sorry, cut here.
Can you hear us, Ritwick?
Yes. I just got disconnected for a minute. Sorry.
Yes. I think you were done with your argument. So
yes.
Yeah. Okay. So it's the related question is, can the proposed amendment be challenged in international courts, saying that it goes against CBD and Nagoya Protocol?
Let me tell you, there's no need, firstly, for the reason that, this amendment will not stand the test of even any high court in India. The way that it is drafted, it will not stand judicial scrutiny. It violates not only CBD, it violates Nagoya Protocol, it violates Article 21, it violates Article 14 very clearly, because it's an arbitrary action aimed very clearly and transparently only to benefit a sector which only exploits the resources. So I'm very confident. I'm not the one I'm suggesting will challenge it, but the fact is, across India, this law will not stand judicial scrutiny at all. I can, my understanding of law, I can assure you there's no need to look at an international forum. The Indian courts are quite competent, and any judge who reads the law will set aside this amendment, definitely. And I hope the JPC actually recognizes this and doesn't allow this particular law to be passed at all. So we should actually have a lot of faith even in the Parliament and the JPC process. And I think that's the purpose at which I think Nima thought about having this one, is as a collective, as people across the country, we need to put pressure on the JPC to actually undo the damage which the government is intending to do through this present legislation.
Thanks, Ritwick. 2 more questions. This is actually very interesting. Is there any middle path where both FEBS is satisfied, but also compliance burdens are reduced to streamline such procedures and afford more people the easy use of traditional medicine, which can potentially save many lives?
See, today, really speaking, this would require, there is no compliance burden according to me. First and foremost, in 90% of the instances, the law has not been implemented. You have most of the biodiversity boards in the country are not even issuing notices. Uttarakhand is an exception. There are a few here and there boards that are there. But most of the biodiversity boards are not even issuing notices to the users of biological resources. So really speaking, where do they get this issue about compliance burden? Is same what they do with regard to environment clearance, that, environment clearance is a very long process. 75 days are lost getting it. It doesn't really stand. These are all excuses to run away from the liability, because, if you are doing and running an industry, you see, if you're a Hakim and a Ved, fine, please do your work. The law allows you. But if you're in industry, well, there is compliance burden with the income tax department. There's a compliance burden with other revenue laws that are there. There's compliance burden with Customs Act. Why is it that only the law which is for the benefit of the public and where the money is going to the actual conservers, that is where they don't want compliance? And let the industry say, where is the compliance burden coming? If you are taking in a resource which has been protected and conserved, what the law talks about is a simple, you give an intimation, the board will do an inquiry, and after that grant approval. How many instances can the industry cite today, right, where the permissions have been denied or there has been undue delay? There is nothing on record. So the thing is that they don't want any policing, anything at all. It's a free for all resources, and that is going to be detrimental. Forget about the resources. The entire Ayush industry will itself be unviable if this is the level of exploitation that they continue doing. All reports are saying, I need not quote them, but all the resources, whether by traffic, whether by IUCN, are said that the level of depletion of biological resources because of the industry is huge. And this is the way to pay back for ensuring the viability of the resource. So my answer to your question, well, I don't see that there is any compliance burden. Yes, there is compliance, and every citizen of the country has to comply with certain laws. As citizens, we all have to comply.
I think we can go ahead with one more question. What will be the effect on biodiversity vis-a-vis FCA recommended amendments? And related to that is its link with RED+.
See, this will be again slightly difficult to connect, but let me tell you that, you look at FCA amendment, this law, as I see it, the Biological Diversity Act and the FCA, I think, are different. the use of the Biological Diversity Act would not see massive deforestation happening. You will not see areas after area being completely devoid of vegetation. These are more sophisticated users of resources, where on the face of it, you can actually have a dense forest and all the herbs, all the medicinal seeds, which are of great value, would have been taken away. So far as the FC is concerned, the purpose is essentially deforestation. So far as this is concerned, it is at a more microscopic or at a varied level. Also, very importantly, when we talk about the Biodiversity Act, almost 95% of the areas that we, or even 90% of the areas where this act is of great use is actually outside forest areas, because is also very important, because it talks also about protection of agricultural practices. It talks about varieties which are cultivated. So the scope is much wider than only forest. So it's about a much larger domain. It's about traditional knowledge. It's about traditional practices. So my point would be that we have to maybe look at both of them separately. Definitely, if there is full loss of forest cover, the biodiversity is also effective. There's no two ways about it. But I think the overall thing is that every law has been diluted, whether it's FCA and others. So this is also meeting the same fate. Only thing is that, so far as Biodiversity Act is concerned, it is much more blatant.
Thanks, Ritwick. Just one last question, which is being repeatedly asked. When is the last date for comments on the draft?
I think the last day is 30th of this month, if I'm not incorrect, if that is the date. 15 days from the date on which it is published. So I think we still have about 5 more days to comment.
Thanks, Ritwick. We don't have the time to cover a lot of the other questions that have come up, but if it is okay with you, then we could share your email ID.
Sure.
On and also your comments, the initial comments that Life has done on the
Yes.
on the draft. I'll hand it over to Nima.
And also this PowerPoint, if anyone wants to use it, please feel free to use this.
Thank you.
That's
Thank you very
great.
much. I
Thanks.
think that would be most useful. Thanks, Meenal. Apologies because we really are running out of time, so we won't be able to take any more questions. But as Meenal said, we will be sending out Ritwik's email ID would be in the chat. Thank you, Ritwik, also for encouraging us to place this trust on the parliamentary process as well as the judiciary process in India. And we do hope that it will work. We are very encouraged by that. Some people have in the chat mentioned whether Life and Kalpavriksh could do a joint response. So we will discuss it and we'll get back to people who would be interested very soon. And the comments, as I said, the written document that you have worked on, Ritwik, will be circulated to all the people in case they would want to have individual responses. Thank you very much. Thank you, everyone. I would like to take 2 minutes to just thank the team at Kalpavriksh, Shruti, Meenal, Tanya, Akshay, and Rudrat for supporting the back end. Thank you to Ritwik and the Life team. And thank you all of you for attending.
Thank you, Nima. Thank you for organizing this and for inviting me.
Thank you.
Thank you.